Antoine LeSean Torrance, 25B148681, and I also have 25B149389, A and B. Mr. Torrance, good morning. How are you?
In this video, you're about to see a perjury sentencing that looks simple on the surface, but carries far deeper consequences underneath. A lie, fear, the loss of an innocent life, and the justice system trying to untangle the truth. Everything comes together in this hearing. Listen closely to how the judge challenges both sides, how the defense tries to humanize the defendant, and how the prosecution ties every action back to the tragedy behind this case. Let's begin.
Is on bond with the circuit court on 2 underlying felony cases. He is bond compliant. As far as I can tell, he's currently bond compliant with this court. I've asked Mr. Torrance if he wants the opportunity to approach the court and ask Your Honor for an opportunity for probation. If the court were inclined to impose the recommendation of a jail sentence, we would ask that the court impose that and hold that in advance and allow Mr. Torrance the opportunity to work on his sobriety. I've explained to Mr. Torrance if it was his option to take some counting time and ask the court to close the file without probation, the court would give consideration. But Mr. Torrance is focused on sobriety, and he would like to show the court that he can correct the error of his ways. He does have a marked criminal conviction history. We do acknowledge that. And we do acknowledge that the 2 charges, which are scheduled for jury trials, I believe in February, through the Third Circuit, are both drug related. And he is using a device to ensure his bond compliance. But more importantly, I do want to know.
I know, I remember this one. This is the gentleman that was begging me, you were begging me.
I was.
Not to send him to jail before
He could be with
Thanksgiving.
his family coming in from out of town, and I think that's well.
That's correct. Okay, I have kids and stuff.
All right, so he appears to have a restricted license because this was an OWBI plea. So he may be able to, he may be able to commute for purposes of probation. And he wants this opportunity to work on his sobriety. He understands that if
These judges know, do these judges know that you picked up this charge after, listen to me, listen. After you were bound over on these drug charges, 2 different cases, you were bound over. Did they know? Do they know? Have they,
Yes,
wait, look,
Oh,
let me finish. They know that you went out and picked up a drunk driving then?
yes.
And
I went in front of him.
I don't, okay, I just wanted to know if they knew.
Yeah.
And then on May 29th, which is after both these other offenses, you went out and had crack cocaine on you. I mean, come on. I mean, if how old are you? You're 41, 2 you'll be in, or 3 you'll be in January, right?
Yes, sir. Yeah, I had.
Why aren't you working?
He's disabled.
Okay.
Cause I would be, yeah, I had little problems, but
The defense's approach becomes very clear here. They're painting Miss Wade as a responsible mother, a working woman, and someone who has never been in trouble before. Their aim is to show that this lie wasn't malicious, but a moment of fear and confusion. They want the judge to see her entire life, not just her one mistake. The real question now is whether this emotional and character-based argument will be enough to shift the judge's decision.
I just was going through a lot after my situation, losing everything, cause my disability. And not being able to do what I love to do, work and stuff, was my perception. So I have been going through a lot. And my kids keep me going, and like we always playing Shrek and Booth in December, so like I am going through a lot, but I just I'm manning up to what I have done. And I just want to be able to, take, to go there and be able to do the AA and they all.
I know. Did he spend any time in jail on these?
We've been down that path. There was an arraignment issue, but I will say this, I believe that you had him taken into custody for purposes of getting the device.
No,
Right, and you were in there for how many days?
seven.
Because they couldn't get they couldn't get the device.
The prosecutor completely changes the tone of the room. This isn't just about a false statement, it's about how that false statement affected a homicide investigation. He's not saying she's a killer, but he is stressing that her lie may have slowed down the search for justice for an innocent victim. This argument adds weight, intensity, and moral pressure to the judge's decision. You can feel the courtroom shift as he speaks.
But I don't know how I get arraigned, but I did 2 months on that day.
You know, with him going to trial in February, he is on bond with the circuit court. And if the court were inclined, my client's got bigger fish to fry, obviously. So if the court were inclined to give him credit for those days that he was in jail waiting to get the tether, he's going to still be in the jurisdiction of the Wayne County Circuit. So
Yeah, this is for his job. And I've been blowing that all the time.
you have this.
Yeah, no.
We know that. We know that.
I don't know what to tell you. You just can't keep doing this. On 1486818, pay fines 300, costs 300, 75 victims' rights fee, $50 justice assessment, 7.25 in 40 days. Credit for 7. You'll serve 33 more now. You'll serve 50 more if you don't pay your fines and costs. On 49389A, 300 fines, 300 costs, 75 victims' rights, $50 justice assessment, 218 in cost of recovery for 943 and serve 40 days. Credit 7, serve 33 more. Those will run concurrent. So that case will run concurrent with 25B, 1486881A, and the other case will run concurrent with 25B, 149389A. And on the open intox, I'm simply going to say fines of 100, costs of 100 or 50, 75 victims' rights, $50 justice assessment, 275 or 30 days credit 7. And those will all run concurrent. So he's going to serve 33 days.
Understood.
And he's going to pay $50 bi-weekly, beginning on March the 2nd. And then when he's done with that, he'll pay 50 bi-weekly on the drug charge. And if he doesn't have money, you call the court. We'll be glad to give you an extension, or you can come in here on or before the due date at 8:30. We could either do it by Zoom or not. You have 21 days to appeal and you have 14 days to apply for a court-appointed lawyer. You'll be out in 33 days.
He's got that device. Can we get that turned in so that goes?
Yeah, that's the, what does he have? The SoberLink or GPS?
Yes.
SoberLink, yeah. Did you get that from the county?
Yes, sir.
Lisa, what's the best way for us to handle that? I could just have him, the county's gonna come get him, he can tell them, and you can send a letter with him or something. You think that's the best way?
Yeah, they'll take care of it when he goes into custody, because
So
I'll have
they'll
the
take care
paperwork
of that.
showing his jail term.
Right. Okay, sir. Good luck. I really wish you well.
Appreciate it, sir. I respect what you're saying and doing that, and I'm mad I can do my job.
Good luck.
And with that, Julia Wade walks out with the final chance. 10 years of deferred probation. If she follows every rule, the felony disappears. But if she breaks even one condition, prison time becomes a real possibility. This case is a powerful reminder that a single lie made in fear can create long-lasting consequences. If you found this breakdown helpful, make sure to like the video, comment your thoughts, and subscribe for more real courtroom analysis.